Hi, my name is Connor Hannigan, and I'm going to be talking to you today about 5 legal tips for people with advanced stage cancer. Just want to thank you for joining us today. I'm a legal fellow at the Cancer Legal Resource Center here in Los Angeles. I'm also a primary caregiver for a person with advanced stage cancer, and so hopefully we can talk about some of the different tips and things to make a difficult experience hopefully a little bit easier. So I wanted to talk about what the CLRC, the Cancer Legal Resource Center, is. We're a part of the Disability Rights Legal Center, and our goal is to provide information and resources on cancer-related legal issues to cancer patients, survivors, caregivers, healthcare professionals, employers, and others that are coping with cancer. We generally don't provide direct legal representation, or give legal advice. We focus more on the educational model in order to empower individuals with knowledge of their rights under the law and give referrals to other legal resources when necessary. We have people on staff who speak English, Spanish, and French, and of course we keep all information confidential. We also have a national telephone assistance line that we operate. We gather detailed information about a legal issue that someone presents with, and then we provide them with customized resources and information that's pertinent to their issue. People can call to ask cancer-related legal questions for themselves, or they can also do so on behalf of someone else. It's always best to complete our online intake form if possible. That eliminates the potential for phone tag if someone calls in, and it normally results in a much faster turnaround. What are cancer-related legal issues? This is a list of some examples. If you're listening to this webinar, you probably experienced some of these and have some ideas about what those can be, but we really run the gambit of different things that we talk to people about. So if any of these are coming up for you, if something else is coming up for you, you can feel free to give us a call on that intake line or fill out an online intake, and we'll make sure that we try to answer that question for you. So one distinction that I'd like to get right into off the bat is that today's discussion is going to be mostly about how federal laws protect cancer patients and survivors. I think it's important to keep in mind that these laws are just a baseline of protections that are available. You may also be entitled to more protections in various contexts, including through state and local laws. Oftentimes employee manuals or employee contracts offer additional protections, or insurance plans have different regulations that may apply. So that jumps us into the first legal tip that we have. Check to see if you're eligible to discharge student loans or student debt. I know that student loans may not apply to everyone facing advanced stage cancer, but they do account for over $1 trillion of debt in America. So I just wanted to touch on them briefly because many people with advanced stage cancer are able to discharge them. If you borrowed certain types of federal loans to attend college or graduate school and you have a total or permanent disability, which is very likely with an advanced stage cancer diagnosis, you may qualify to have your loans forgiven or discharged so that you don't have to pay them back. The federal government has a program called the Total and Permanent Disability Discharge Program that applies to only very specific types of loans, such as William D. Ford Federal Direct Loans or direct loans, federal family education loans, and or federal Perkins loans. The program also applies to individuals who have to complete a teach grant service obligation. The total and permanent disability discharge only applies to federal loans that you borrowed for college. Private student loans borrowed from a bank or other financial institution are not eligible for the TPD discharge program. Private loans are not subsidized or regulated by the federal government, and so they don't have the same types of discharge, deferment, or forbearance options that are available for federal loans. So if you're unable to pay a private loan, it's best to contact the private lender directly and find out if you can negotiate some of the debt or come up with an alternative repayment plan or a temporary delay in payment, such as a deferment or forbearance. But back to the total and permanent disability discharge. Before these types of loans can be discharged, you must fill out an application and provide information to the U.S. Department of Education to show that you're totally and permanently disabled. So that's the standard that they have. There are different ways that you can show that you meet this totally and permanently disabled status. It depends on whether you're a veteran or if you're receiving Social Security benefits such as SSDI or SSI, or if you have a long-term disability that prevents you from working. So depending on your situation, you'll have to provide evidence about either Veterans Affairs disability, evidence of SSI or SSDI determination, such as a determination letter, or you'll have to provide a physician certification that shows that you have a disability that is expected to last at least 5 years or result in death. If you're approved at this point, then your loans are discharged, and it's possible that you could have a 3-year monitoring period where they will look back at your case and see if you are totally and permanently disabled or if something has changed. So one thing to keep in mind are the tax implications with a total and permanent disability discharge. So an important thing to note is that if loans are discharged, any amount over $600, if you have over $600 in debt that's discharged, it's considered taxable income unless someone is determined to be insolvent. So it can be very important to work with a tax professional if that's possible for you. A lot of nonprofits or cancer centers will have tax professionals that assist them at certain times of the year that you can check in with that hopefully will be able to assist you if this insolvency exception applies. But it's a good idea to double check what the implications of this would be with a tax professional, particularly if before you go into jumping through all the hoops to discharge the loans. So once your loans are completely discharged, the amount of the debt that's discharged gets reported as taxable income for the year that the loans are forgiven, in addition to any taxable income you may already have. So that applies, as I said, to any discharge loan of $600 or more in a given year. You'll be sent an IRS Form 1099-C that you have to fill out and include when you file for your taxes. If you're unable to pay the IRS the amount that's owed from your discharge loans, which is generally going to be the reason why you requested a discharge in the first place, then it might be best to contact the IRS and ask if they can negotiate a repayment plan with you. So although the IRS isn't required to negotiate that repayment plan, there may be different options available for individuals who can't pay the full amount that's owed after the TPD discharge. Like I mentioned before, the IRS has that insolvency exception that applies to taxpayers who receive a TPD discharge. The taxpayer is considered insolvent when the amount of taxes that he or she is responsible for is much greater than the amount of assets that the taxpayer has. So as a result, the discharge debt is not considered income for the taxpayer, and he or she does not have to pay taxes on that amount. So to apply for an insolvency exception, you have to fill out the IRS Form 982 when you file your taxes the year after your loans have been discharged. Here are just a couple of good resources that you can look into for more information about discharging student loans. Additionally, please keep in mind that you might be able to get a deferment or a forbearance regardless of what types of loans you have, either federal or private. A deferment is a period during which repayment of the principal balance of your loan is temporarily delayed and can be effective for temporary losses of wages or funds. During a deferment, you don't need to make payments, and what's more, depending on the type of loan you have, the federal government may pay the interest on your loans. Some accepted reasons for deferment of repayment include inability to find work, a period of economic hardship, or a period of active military duty. To request a deferment, please contact your loan servicer. Your loan servicer is the one that will make the decision as to whether or not to grant your deferment, and there might be limits on how many deferments you can request. The other option is potentially a forbearance. So if you can't make your scheduled loan payments but don't qualify for a deferment, your loan servicer may be able to grant you a forbearance. With that, you may be able to stop making payments or reduce your monthly payment for up to 12 months. The problem is that interest will continue to accrue on the subsidized and unsubsidized loans, but to request a forbearance, you can contact your loan servicer. You can also request a discretionary forbearance where the lender can either decide to grant or not to grant the forbearance as opposed to a mandatory forbearance for in the case of financial hardship or loss. So you can request that discretionary forbearance for the financial hardship or illness. So the second legal tip that I wanted to jump into was to request workplace accommodations before performance is affected. So this is a situation that we hear about on a daily basis. Employees aren't required to disclose to their employer that they have cancer, but if your work performance is going to be negatively impacted by your diagnosis, it's important to ask for reasonable accommodations from your employer in advance if you qualify for them. So although laws exist that might protect people with cancer against discrimination, employers aren't prohibited from taking negative actions against an employee if their work performance is suffering or they aren't performing the essential functions of the job and their employer doesn't know about their need for accommodations. It's generally the responsibility of the employee to ask for changes to the work environment before their work suffers. So this request could either be made to your employee supervisor or to a human resources representative. So the first law that I'd like to talk about is the Americans with Disabilities Act. The ADA is a federal anti-discrimination law and pertains to all phases of employment, including application and interview. So if you're not currently employed right now, but you're looking for work, it's important to understand that the ADA does apply to that interview application stage as well. The ADA does not apply to all employers, though. It only applies to those private employers with 15 or more employees. Many states have extended similar protections to smaller employers, but not all. It protects employees against discrimination if the employee has a qualifying disability and can perform the essential functions of their job with or without reasonable accommodations. So there are three parts to that definition. One is that you have an impairment. The second part is that it limits a major life activity. And the third part is that the limitation is substantial. It's really important to understand the definition of disability in different contexts because certain laws define it differently. So when you're looking to see if a law might apply to you as a person living with advanced stage cancer, look to the definition of disability that they use in that law first, and then see, does that apply to me? Okay, what are some of the other requirements that apply as well? Oftentimes there's a gray area there that might not be cut and dry, so you can check with us or check with another organization to see if it does, but oftentimes you'll be able to determine that. So cancer can be a disability under the Americans with Disabilities Act, but it's determined on a case-by-case basis. And it's important to also note that it's not just the diagnosis and the illness itself, but also the side effects of the treatment that can be considered substantially limiting someone. So let's say your cancer diagnosis isn't causing you to be limited in any of the life activities that you do, but maybe the chemotherapy has some really bad side effects that are affecting your ability to breathe and talk and walk and do daily living activities, for example. Then you would still be eligible as substantially limiting a major life activity due to that impairment. So what is a reasonable accommodation? An accommodation is reasonable if it's effective and it meets the individual's needs in that circumstance and does not cost the employer an undue hardship, such as costing a substantial amount of money. So the Americans with Disabilities Act allows for people with disabilities to get accommodations in the workplace that allows them to do their job, and that means that individuals might be entitled to these reasonable accommodations. An employer has to keep the employee's request for a reasonable accommodation confidential, so they can't tell any coworkers about the accommodation that you've requested. Employers also have the right to request medical documentation showing that either the accommodation is needed or that the employee has the present ability to perform the job safely. Caregivers and individuals that are regarded as disabled but not actually physically disabled are protected from discrimination, but not entitled to reasonable accommodations under the Americans with Disabilities Act. So once someone requests a reasonable accommodation, both the employer and the employee have to engage in a good faith negotiation to explore and implement the most effective accommodation for the employee. And that's called an interactive process between the employer and the employee. So let's say standing up is really hard for you at work, and that's part of your job. Well, you could request a reasonable accommodation to have a stool at your job so that you could potentially sit down or take breaks if that's possible, and then it's up to your boss to see, is that reasonable? Is it going to be a $5,000 stool, which might not be a reasonable accommodation because of the cost, or is it going to be a $10 stool, in which case you can negotiate that with your employer, and hopefully that wouldn't provide for any undue burdens. So the next law that I wanted to talk about is the Family Medical Leave Act, or FMLA, and that provides 12 weeks of unpaid job and health benefit protected leave per year for someone to either take care of themselves or for a covered family member if they work for a covered employer and they meet eligibility requirements. So this is commonly referred to as FMLA. I think it's important to note that this doesn't just apply to us as people who are taking care of themselves with advanced stage cancer, but also a covered family member. So if it turns out that you need some help, you can look to one of these covered family members who should hopefully be able to take some leave from their work. One of the problems with FMLA leave is that it is unpaid, and so that can be really difficult for some people to take, but the benefit of it is that that person's job is protected, so they can go back to it and step back into the same place that they were to continue doing their job in the next year. So who are some of the people that can take FMLA leave? Either yourself, as we mentioned, or a covered family member. And a covered family member includes either parents, minor children, or spouses. So those are the people that are allowed to take the FMLA leave. Unfortunately, siblings are not allowed to take leave under FMLA, and so that can be a problem if it's a sibling that you need to take care of, or you're a sibling. You have to find someone else that fits into these categories, so that it's a covered family member that people can take that leave for. You can take advantage of FMLA if you've worked for an employer for at least 12 months. It doesn't have to be all at once. Maybe you've worked only a few months a year for that employer, but it's added up to 12 months, well, then you can take FMLA leave. And it also has to be at least 1,250 hours in the last year. So you do have to have worked at least a certain period of time within the last year to take the FMLA leave. And then there are some requirements for employers that are eligible for FMLA leave. It qualifies, all public employers qualify, government, local, state, and federal employers, and private employers with 50 or more employees within a 75-mile radius. So let's say a bank has two offices that are 20 miles apart, and they have 30 employees in each office. Well, that's 60 employees, so they have more than 50 employees, and those two branches are less than 75 miles apart, so they would qualify as a large private employer. If the two branches were spread out much farther than 75 miles, it would be much difficult for them to cover those shifts of the person that might need to miss, and so I think that's why they have that requirement. So we think it's important to talk with your employer about going on leave if that's something that you or a family member might need to do. You may have to provide medical certification. Employers do have to comply with all applicable laws regarding the confidentiality of medical information, so therefore the employer must keep the employee's medical information and records separate from their personnel files in order to protect their privacy. We generally suggest that it's best to get a general practitioner's letterhead that can write this certification letter, one that doesn't say oncologist on it, so that way an employer doesn't know that it's necessarily a cancer diagnosis in case there's a potential for discrimination or disparate treatment based on knowing that it is cancer that the person's taking time off for. So FMLA leave is for 12 weeks. That can either be taken in a whole, an entire 12-week block, or it can be taken at certain intermittent times. To use that intermittent, maybe taking a few days here or a week here, separated out over a longer period of time, that's only possible when it's medically necessary to take that time. So there has to be some sort of medical reason for why you need to take it in those blocks like that. You can take those small blocks in a small amount of time as the employer has for taking time off. So if the employer says that you can take an hour of time off for a certain day and that's the time block that's used, well, you could take an hour of FMLA leave for a medically necessary reason. If you don't think that you qualify for FMLA or you need additional leave time beyond the 12 weeks, then you can ask for leave time as a reasonable accommodation under the Americans with Disabilities Act. For some employers, it might be reasonable to allow you to have leave time under the ADA or to have extra leave time under the ADA. Courts have held that the ADA generally does not protect workers who have erratic or unplanned absences and whose accommodation involves being absent from work. So to be protected under the ADA, you must be able to perform the essential functions of the job. And if attendance is an essential function of your job, which it is for many jobs, then that's not protected under the ADA for absences. It is considered an undue burden for your employer to have to keep it on the job open for that extended period of time. I think it's important to check your employee handbook to see what your company's policy is about sick leave. Some employers have a very generous medical leave policy that provides employees with additional protections. So oftentimes, if this is something that you're considering, trying to extend FMLA leave or looking at what your time off is, start with the employee handbook as well and see how that can complement the FMLA leave and ADA leave. We also suggest that if you need additional leave time, asking for an indefinite period of leave time, because it can be often impossible to know how long a treatment is going to go on. Certainly living with advanced stage cancer, knowing when you might be feeling well enough to potentially go back to work, if that is possible for you, it can be impossible to determine that. But if you do have a definite end date as to when you might have a treatment that might finish, you might feel well enough to go back to work, usually asking for that definite end, I need an extra 2 weeks of following the FMLA time, that's something that you can request, and generally it would make an accommodation more reasonable and hopefully more likely that an employer would grant it. These are just a few organizations that provide really great practical information for people who are either entering the workforce for the first time after a cancer diagnosis, or people who need assistance with accommodations. So we recommend Cancer and Careers or the Job Accommodation Network as places to contact for some additional information for employment resources. We also have a large list of state-specific employment resources, as we do with most issues that come up, so feel free to give us a call if there are some resources that you're looking for that are local to you. So I want to move on to the third legal tip in our 5 legal tip series. And the third legal tip is to request compassionate allowances for Social Security programs to expedite approval. So I just want to talk a little bit about what SSDI and SSI, SSDI being Social Security Disability Insurance, SSI being Supplemental Security Income, and I apologize for all the acronyms, but you will generally hear them when people are discussing these programs, and they can be difficult to keep straight, especially because both of these start with SS. But let's get into this, and we'll try to explain it a little bit and make it a little bit clearer. So in order to receive these benefits, you have to apply for them through the Social Security Administration. You also have to meet the Social Security Administration's definition of disability. And their definition, like we said before with the Americans with Disabilities Act and with FMLA, is important to understand when you're looking to see if you're eligible for it. For Social Security, it means that you cannot work due to a severe medical condition that is expected to last at least 1 year or to result in death. So both of these two programs provide long-term disability benefits because the disability is expected to at least last a year or result in death. The key to qualifying for these benefits is to show how your medical condition is keeping you from working. That's why it's important to collaborate with medical providers to document your medical history. It's important that you appeal any denial of benefits, as the system can be set up to deny most people. So don't get discouraged just because your disability application was denied. Look to see that you meet this requirement of someone that's expected to not work for at least a year, or have a severe medical condition that's keeping you from not working for at least a year, or potentially resulting in death. So there is no waiting period for SSI, supplemental security income. That's just based on your income and assets. So all you do is look to see what the income and assets level is, and if you have a disability that qualifies here, you have limited income and assets, you should be eligible for SSI. An important thing to note is that SSDI has a 5-month waiting period, so it can be important to apply for that as soon as possible, and to try to remember, if you're currently working and you're thinking about switching on to SSDI, SSDI is based on your employment history. You need a certain number of employment credits to be eligible for SSDI. So after having enough of those employment credits, we could assume that you were working prior to going on SSDI at some point. But just know that there's that 5-month waiting period that is going to come in when you won't be receiving SSDI benefits, and that could be a difficult time for people to cover those costs during that time period. So if you can plan ahead for that, it's really important to do that. You can apply for supplemental security income if you do have limited income and assets, and also apply for SSDI if you have a work history. And a lot of people receive SSI before they receive SSDI, and depending on the amount of SSDI that they receive, they'll either continue receiving SSI benefits that may be reduced because they're receiving income, or they may stop the SSI because the SSDI income puts someone out of the SSI income bracket. So as we talked about, with the similarities, they have that same definition: to be unable to do substantial gainful activity due to a physical or mental impairment that's expected to last at least a year or result in death. SSDI is based on prior work history, or whether you paid into Social Security, and an inability to continue working due to a disability. And as we mentioned before, there is that 5-month wait period for SSDI, so it's important to try to budget out that there may be 5 months where there might not be any income coming in for a person who's applying for SSDI benefits. And also, after 2 years on SSDI, so you're eligible for Medicare if you're under age 65. So that's another thing to keep in mind as well too. If you're under 65 and you're applying for SSDI, you are going to have to think about how you're going to be paying for insurance during that time period. And we also have some more resources about different health insurance options. So if that's an issue for you, please give us a call. Please fill out an intake form. We'll try to point you in the right direction. SSI, as I mentioned, is based on assets and income, not work history. And someone is usually eligible for Medicaid as soon as they're eligible for SSI, because Medicaid is a joint federal state-run program, but that's based on assets and income. So if you're eligible for SSI, a lot of people are also eligible for Medicaid at the same time. Okay, we'll skip that. So for compassionate allowances, you still have the 5-month wait period, but the compassionate allowances for SSDI, but the compassionate allowances program is a way of quickly identifying medical conditions that are presumptively eligible for Social Security disability benefits based on minimal objective medical information. So if your condition, and a lot of advanced stage cancers do, fall within one of these conditions that are listed on this website, then make sure that it's obvious in your application that you are requesting a compassionate allowance. There isn't a box for compassionate allowances on the Social Security application if you do it online, or if you fill out a paper application, but if you just write in one of the boxes that requests a different question, also I'm requesting a compassionate allowance as my condition is listed on the compassionate allowances website, then hopefully that will identify that for the person that's reviewing your application. And the people that do review those applications they check for this anyway, but sometimes it's just good to highlight that for them so that you make it a little bit easier on them. So the Social Security Administrative Blue Book is also a good source to look at the types of information that can and should be included on an SSDI or SSI application. This is a listing of conditions that the Social Security Administration has already determined are likely to affect a person's ability to work. So you can get a good idea of what successful applications have looked like and what the important things are that they're looking for based on going to this website and determining if you have conditions that match up with prior conditions that were successful in these types of applications. So I just want to move on to the fourth legal tip. Involve your medical team with insurance issues and request compassionate use to access medications. So this applies to many of the issues that cancer patients face, but we're going to talk about some of these insurance issues in terms of not taking no for an answer. So these are some tips just regarding insurance appeals. You can appeal denials of coverage or insufficient coverage. It's important to keep the denial letter. A lot of times they'll have information about how to go about appealing a denial. And it's really important that you follow appeal dates and deadlines. Generally, insurance companies are very serious about making sure that people do properly follow the rules and deadlines that they have. I think it's also important to obtain a copy of a current insurance policy that you have, or an employee benefits plan or a benefit plan that you have, just to make sure that you know what those rules are. We mentioned involving your medical team as an important thing. I think that really just helps people reduce the workload that they have of making sure that all of the things they have to do. A lot of times your medical team can directly contact an insurance company for you and let them know that you do need the medication or the treatment that they're requesting, and that sort of takes out some of the legwork for you. A lot of times medical hospitals or places that you go for treatment might have insurance specialists that work there. It's important to get to know those people, to really talk to them about things that are going to be successful. They deal with insurance companies every day, and try to get any tips or information from them that they have. Another thing that's important to do is request urgent or expedited on your application if you need a quick response. And these are sort of magic important words that signal to an insurance company that this matter is a time-sensitive matter. So don't write these on everything that you send to your insurance company, but if you do have something that is time-sensitive, make sure that you request that you need it to be urgent or expedited, and that'll let the insurance company know that they need to follow their urgent or expedited time frames for getting back to you. There are also patient assistance programs that are available, and I think it's important to look into these if cost is is something that's affecting you, and generally the cost for these for receiving treatment for advanced stage cancer can be very expensive, so I think this is probably going to be important for most people. Some of the things that we wanted to mention were just looking into patient assistance foundations. I think it's really good to go into, based on a cancer diagnosis, looking at different foundations that apply to your cancer diagnosis, because a lot of them are separated out based on diagnosis, and seeing if they have any funds available that you can access and spend down through the year. Once you spend down that amount that they give you, oftentimes you can reapply for more funds if you do need more funds. And so these are just amazing resources for people living with advanced stage cancer. Every company also has a patient assistance company generally that you can contact to gain access to a medication. So if you're not able to get a medication that you really need based on cost, contact that patient assistance company. You can contact the person that's supplying the drug directly, ask them who their patient assistance people are, get in touch with them, and then hopefully they will help you gain access to that medication at a price that is a little bit more reasonable. we had to do this personally, trying to access some medication. We contacted a patient assistance company, and they immediately reduced the price of the medication that we were trying to access. So I think it's really important just to do the groundwork on this. It was, not a fun phone call, but the people that we contacted were extremely nice, and this is something that they have to do all the time. And so it's not something that people enjoy doing, but I think it's so important just because not many people have the money to just pay for all of these costs that come up. These are two also websites that I think are really good. Patient Advocate Foundation, Survivorship from A to Z. We're not connected with either of those organizations, but I think they have really good resources on there if you're available to check them out. So one thing also that I wanted to mention, there are some different rules with obtaining prescription medications. Medications first have to be approved by the Food and Drug Administration, or the FDA. Until a drug is approved, it can't legally be given to anyone except through an approved clinical trial or a manufacturer's compassionate use program that's approved by the FDA. So compassionate use programs allow a manufacturer to give certain individuals a medication that's being tested in clinical trials before the FDA has made a decision about approving or not approving the drug. Compassionate use programs are usually reserved for patients with limited treatment options, so you can also contact your doctor for assistance in gaining access to compassionate use of the medication, either directly or through the manufacturer. So let's say there's a person with limited treatment options that are left, there's a medication that just came out that's still in clinical trials that they really think would help them medically. They can contact their doctor, contact the person that's putting on the person that owns the drug that's in the clinical trials. They can contact them directly and ask to be a part of their compassionate use program, and then hopefully gain access to that medication to gain some assistance there. So when the FDA approves a drug, it's approved for certain conditions or indications, and that's called being prescribed on the label. Regardless of what the label says, a physician can legally prescribe an FDA-approved drug for any reason, and that's called prescribing a drug off-label. So it's important to note that your insurance company might not approve coverage of a medication that's being prescribed for you off-label, but there might be some situations where the side effects of a certain drug that was approved for some other disease might be helpful to you if you have that side effect. Say, you have, a problem with diarrhea or something like that. There might be a side effect of another drug that's really good at stopping that. You might be able to get that drug off-label if you've tried a lot of other things and gain access to that medication. So supplements are different, and while they're not subject to FDA approval, they can't claim to treat a disease or a disorder. So sometimes a doctor can also try to appeal for a brand name drug if it's necessary because a generic drug won't work for some other reason. Oh, and formulary lists. So each plan has a formulary or list of approved medications. Formulary medications can usually be prescribed without a pre-authorization. These are different medications that have been prescribed for different diseases already on a usual basis. And so if you have that same condition, you can look at the formulary list to see what the types of drugs that are normally approved are going to be, so you can gain access to them. Okay, and our fifth legal tip is don't just talk about end-of-life wishes, document them. So talking about death can be really difficult for many people. Even those who are often comfortable about it might not realize how important it is to have their wishes actually written down in official documents like an advanced healthcare directive or a power of attorney or wills or trusts. Having difficult conversations early is important so that the patient can create valid legal documents while they have the ability to understand and make informed decisions. If an illness is progressing, the longer someone waits to create these documents, the greater risk that they might be called into question due to a lack of capacity. So if you have these documents already, it's important to check to make sure that they're up to date, that they follow current state laws, that all the assets, including new assets that are acquired, are covered, or if assets change around, that's accounted for, and that the correct beneficiaries are named. It can be helpful to talk with an attorney to avoid common mistakes, which could result in making the documents invalid. Documenting these wishes is really important, even if you think that everyone, even your family and friends, know exactly what you want. If it's not in writing, it might not be sufficient. That's why that's true when it comes to decisions about healthcare as well as decisions about dividing up personal property. So there are two parts to advanced planning. The first part is the people and property part of it. And you can think of wills and trusts and powers of attorney for finances. And the second part is the healthcare part of it, such as advanced directives and the component parts of that, such as power of attorney for health and other wishes. For the first part, you want to designate someone to manage your property and finances in a power of attorney if you should become unable to do so. And it's best to name recipients of the property in a will or a trust. For the second part, you want to document your wishes for care in advance in an advance directive for healthcare, and then you can name someone to make medical decisions in case you become incapacitated. So one very basic tool that we are probably all familiar with in terms of advanced planning is a will. That's a document where you lay out where you want your property to go to and who you want it to go to. There are important formalities that are needed to create a valid will, and these rules about what constitute a valid will are determined according to state law. So it's important to consult local resources, or you can call us at the CLRC to find out how to create a valid will in your state. In some states, there are 3 different ways to create a will, such as a holographic will, your state statutory will, or you can have your will prepared by a lawyer. Holographic will means it's written in the person's handwriting, so you just write down where you want things to go, just yourself. It's not recognized in every state. It's not something that has to be witnessed by other people, making sure that you're the person that wrote that will. Statutory wills are ones that you can go online, such as I have an example of the California website to go online to look at a statutory will, and then you just fill in the blanks of where you want things to go, and then have it notarized. Another way you can do another way to create a will is to hire an attorney. This is definitely the best way to go about making sure that your will is going to be valid. They can make sure that your will conforms to state laws, and they can offer suggestions to help you understand the different ways that property can be transferred and help to make it economical for your family in the long run. So what happens if you don't set up a will? If someone dies without a will, then it's referred to as dying intestate. State law determines where a person's estate will go at that point, but we just put up the table of consanguinity on here so that you can see how complex things can really get after you start having different assets going out to different people in terms of who your next of kin is going to be. So if you don't have a will, there's no way to have a say in what that distribution is going to be. So it's really important to think, even if you don't think you have a lot of property, even your pets can count as property, and a lot of times people can forget to make plans for them. So it's really important to just think ahead. You can save everyone a headache by making sure you go through this process a little bit. One example in the recent news is that Prince just recently passed away without a will, it looks like, and now it looks like there's going to be a lot of issues with a complex estate in that situation for the people that are his family members. And this can lead to the breaking up of a lot of families in certain situations, or a lack of friendships, and that's why I think while it's a difficult conversation to have, not having a will provides a lot more difficulties for the people that you care about. So I just wanted to briefly explain what a trust is as well. That's an arrangement whereby one person called a trustee holds legal title to property for another person called a beneficiary. So there are many types of trusts. You can create them separately while you're alive, called a living trust, or through your will, which is called a testamentary trust. The main advantage of a living trust is that it avoids a family having to go through probate court after death, which can be expensive. So a lot of times with trusts, there are more costs that you have to pay up front to establish the trust, but when you compare those costs to probate costs, it can be less expensive in the long run. Not every will necessarily has to go through all of the expensive probate hurdles. Sometimes that can be much simpler if it's a smaller estate, but it's important to look to your state laws, which an attorney can help navigate you through to make sure that you do the most cost-effective and easiest way for the people that you care about. So a power of attorney for financial affairs is a legally binding document that you prepare or have prepared for you to sign, where you choose a trusted person that's known as your agent to act for you if you become incapacitated. Incapacitated meaning unable to act or speak on your own behalf. Whether or not someone is incapacitated is determined by a doctor or a judge. So for any power of attorney to be valid, it has to be signed and has to be notarized depending on what your state's requirements are. So you have to look to your individual state for these requirements. The power of attorney ends as soon as someone passes away, so that agent doesn't have power over financial affairs after someone passes away. If they have a will, that's when your will would take effect. I think it's also important to check with your bank about whether they have their own forms that they want filled out. Even though they should be honoring your power of attorney, you can make it a lot easier for everyone involved if you fill out your bank's forms so that they match up with your power of attorney so that people don't have to jump through any extra hoops. The two most common types of power of attorney for financial affairs are durable power of attorney and springing power of attorney. If a person wants an agent to start making decisions for them today and for that agent to continue making decisions for them when they become incapacitated, they would create a durable power of attorney. A durable power of attorney will start now and stay in effect when you become incapacitated. If someone wants an agent to act only when they're unable to make their own decisions, when they're found incapacitated, they would create a springing power of attorney, which is the most popular. Whether or not someone's incapacitated is determined by that doctor or judge. So talking a little bit about healthcare planning ahead, a living will, also called a directive to physicians or an advance directive, is a document that lets people state their wishes for end-of-life medical care in case they become unable to communicate their decisions. It has no power after death. So now that we've covered a little bit about how to plan for your property, we're going to talk about some more tools as to planning for your medical treatment and instructions for foregoing medical treatment at the end of life or when someone's not able to make these decisions for themselves. Again, the requirements for each of these might vary by state law. They do vary by state. So if you have any more specific questions as to what makes one of these documents valid or invalid, you can contact the CLRC or contact an attorney in your state. At the CLRC, we also have resources for different attorneys and nonprofits in various states that we can connect you with as well. So advanced healthcare directives are written instructions that state a person's wishes about the medical care and treatment they want to receive if they are unable to make medical decisions for themselves. Advanced healthcare directives are intended to avoid unwanted care, reduce suffering, and ensure that a person's wishes are honored at the end of their life. For example, you can state your desires regarding life-sustaining or life-prolonging medical treatment or pain relief. In some states, there can be 4 different parts to this advanced healthcare directive, such as a power of attorney for healthcare, instructions for your healthcare, organ donation, or primary physician identification. And that just includes information about how to get a hold of a person's doctor so that they can contact your doctor if needed in an emergency situation. I think these are really important as well. We had a friend who was unable to communicate her wishes to her family when at the end of her life. Her family was all there in her hospital room, and they were left with a choice of having her be in more pain but able to communicate more with the family, or in less pain and less able to communicate. And the family members were split on what would be best for her. They checked the advance directive. It said that she wanted to be in less pain, and they made sure that that was the case, and they respected that. And so it sort of ended any family drama at that point, and made a stressful situation less stressful and allowed them to focus on what was important. So the power of attorney for healthcare, depending on what your state calls it, names a person, either a relative, a friend, or someone else that you trust to make medical decisions for you when you're not able to. The power of attorney deals with all medical decisions unless you decide to limit it. You can also give specific instructions about treatments that you want or don't want, or about other issues that concern you. So when you're thinking about who to name for this power of attorney for healthcare, it's really important to consider someone who's trustworthy, someone who shares your values, and someone who you've hopefully talked to about what your end-of-life wishes are. You may want to name a parent, or you may not, because making those decisions for someone with such a close relation to you can be extremely difficult for that person. So it's important to think about how someone would really be able to manage that. The physician order for life-sustaining treatment, or POLST, is another tool for planning ahead for your healthcare. It's similar to an advance directive, but the POLST is completed with the approval of both the patient and the physician, and it guides emergency medical treatment. It has the force of a physician's medical order and remains with the patients wherever they receive care. It should go in the patient's medical file and be attached to the patient's chart. It's usually on a bright pink form so that it can be easily located, and that's in contrast to the medical directive, to the advance directive. Some states also give patients and their doctors the right to death with dignity. The states that do have a right to death with dignity generally have specific procedures for making and granting such a request. And this allows, in these states, mentally competent, terminally ill patients have to get a physician's prescription to ingest medication to achieve peaceful death if they have a suffering that becomes unbearable. A lot of research has shown that the people who do decide to gain access to this medication don't end up using it. Some of them do, but I think generally just giving people the peace of mind so that they know they could access this medication if they had extreme suffering and pain can sometimes help people through part of this process. So in every state, people who are at the end of their lives have certain rights regarding end-of-life treatment, and planning ahead ensures that your rights will be protected. Those rights include the right to palliative care, or care that focuses on pain abatement, the right to refuse food, including through a feeding tube, the right to refuse medical treatment, the right to palliative sedation, and this can also help allay people's fears about pain and suffering at the end of life, because they can make sure that they're just sedated rather than in extreme pain. So that should not be a concern that people have. People also have the right to have their pain adequately managed and the right to have their wishes upheld. And that's through things like the advance directive or the POLST. They have the right to have those documents enforced. So if someone didn't plan ahead, something that might kick in is called a conservatorship. A conservatorship is a judicial procedure that appoints someone to take charge of a person's legal, financial, and personal affairs when they're deemed not legally competent. To create a conservatorship, a petition may be submitted to the court by someone who is asking to be appointed as the conservator. Generally, that can be a spouse or a relative or a friend of the proposed conservatee, or an interested state or local agency. The petition must contain information on why the individual cannot manage his or her financial affairs or make decisions concerning his or her personal care. The court will conduct an investigation and hold hearings to determine if the person is incapacitated and whether appointment of a conservator is required. So this is just one example of why it's really important to fill out these documents, because if you fill them out, you get a say and you get to control what the end-of-life care looks like. And and that can be really empowering for people. But if you decide not to plan ahead and you decide not to fill out some of these documents, unfortunately, then you're leaving it up to the state. You're leaving it up to a court to determine who is going to be making all these decisions for you. And the court might not always pick the same person that you were planning on picking for that situation. One example of a famous conservatorship is Britney Spears, having her father be in charge of her conservatorship. That actually may be working out well for her, so that's great. Some situations it works out fine, and other situations it doesn't work out as well. So if advanced directives seem overwhelming to you, you might want to look at something called the 5 Wishes. This is also another thing that we're not affiliated with, but I think it's a good resource as well. So while it's always best to ensure that you have an attorney look over any legal documents, that's not necessarily possible for everyone. The 5 Wishes meets the legal requirements for an advance directive in 42 U.S. states and the District of Columbia. In the other 8 states, the completed 5 Wishes form can be attached to your state's required form. It does cost $5 to request the actual form, but I think it asks some great questions and gives good suggestions about what someone might want their advanced care to look like. Just how comfortable they want to be, what they would like people to make sure that's taken care of for them. This is also something that's great to go over with your caregiver, because I think some of those questions, they're difficult questions, but I think it gives the caregivers a chance to really understand just how complex the process can be, and to go through that with somebody else and understand that asking these questions are not easy, but they're really important and they really help everyone out. That can be helpful for a lot of people. So I really want to thank you for taking the time to listen to this webinar. If it's been helpful to you, we are a free resource for people. Our telephone assistance line is free, so you can either fill out the intake form or give us a call. That's free. I know that a lot of people living with advanced cancer don't often have a lot of resources to make donations, and that's okay. If you do have the ability to do that, we would love it if you donated to our organization, or if you know of anyone else that's making donations, if you could please suggest that they think of us. It would really help us keep these services free to everyone. So we're going to end the webinar there. If you have any questions, you can always contact us at our website or at our phone number. And I hope you have a wonderful rest of your day, and take care and good luck.